I don't think very many judges would like to be influenced by a prior judge or a brother judge. The opinion of a brother judge would not at all.
There is a feeling that if the opinion, legal opinion, comes from a Supreme Court judge, the lower judiciary is overwrought.
It doesn't make a difference at all, because in appeal there may be someone who might like to put the Supreme Court judge in place. I think
let me respond to this. The Constitution bars only to plead or to act in a court of law, so far as the apex court judges are concerned. Therefore, I ask myself, is it open to put any kind of a restriction on the legal opinion to be tendered in any particular matter by an ex-judge of the Supreme Court? To mine, it would be unconstitutional. That kind of a restriction cannot be imposed.
But we already have some restrictions, Mr. Gupta. As you know, that if a judge retires from a high court, he can't practice in the same court.
Precisely, I am saying so, that the restriction is not to plead in any court, not to act in any court. And this particular kind of legal opinion which is being tendered is not within the parameters of pleading and acting in a court of law. Surely is beyond the purview of that.
But you don't think the lower judiciary gets influenced or overawed by the opinion of
Let me respond to that. You know, first of all, Supreme Court judge giving an opinion, would it not overawe a High Court judge? I ask myself first of all. A High Court judge takes an oath to act without fear of favor. Now, he has to see what the law is. Legal opinion may help in formulating his mind. The memorial lectures, Hamlin lectures or Tagore law lectures, they are the good aids in interpretation of law. Every day the Supreme Court is making use of those. And consequently, I hold it's high time that we have the best of expert opinion, consider the entire matter within the canvas of law and interpret that law.
I'll protest on that. You work on a presumption that the lower judiciary is influenced by the opinion, an opinion expressed not on the judicial side, opinion given on a particular subject by anyone.
Well, let me just check with Justice Gill. Justice Gill, should retired Supreme Court judges tender legal opinion?
They do.
No, in fact, I'm of this view that not only Supreme Court judges, High Court judges also should not give any opinion. I'll put a question. I'll put a question to myself and answer it. Are there not competent, outstanding lawyers who can give opinions? Are there not legal firms who are just doing advisory work? They have teams of 40, 50 lawyers sitting in their offices, and they're doing only advisory work, giving opinions. Why must a litigant go to a Supreme Court judge or a High Court judge for opinion? There's a motive in it. There's a motive in it to overawe the judge, the lower judiciary judges, and then put it before the judge when there's argument. Here we've got a legal opinion of the former Chief Justice of India. Here we've got it from a retired Supreme Court judge or a High Court judge. The litigants are very smart. Especially these corporate litigants and all who've got the money, they're very smart. Then why should a High Court judge or a Supreme Court judge take money in wads of money to give opinion? And then going abroad and taking that opinion and going and giving your views out there. This is also
Justice Gill, let me get the view of the panelists here. Ms. Gupta, yes.
See, this kind of a situation would undermine the very prestige and independence of the judiciary. That means we suspect our judges that they're going to be overawed by the opinion tendered as such. This goes to the root of the entire system.
Do you agree with Mr. Gupta?
No, I entirely agree with him. If we presume that our subordinate judiciary is going to be overawed by a High Court judge's opinion, we would presume, we will have to draw another conclusion, that a High Court judge would be influenced by the Supreme
That's what
Court
I'm
judge.
saying.
I mean, I don't agree.
Justice Gill, would you like to respond to that, please?
And we differ
Yes,
on
definitely.
judicial verdicts.
Litigants, especially the corporate listener. I want an answer from to this point where there are legal firms, there are outstanding lawyers sitting, let's say in the Punjab Haryana High Court,
Please.
in the Supreme Court, in other high courts. Why not their opinion?
Why are the litigants, Mr. Gupta, why are the litigants not taking the opinion of the private
I'll give an
lawyers?
answer.
Say the opinion of the private lawyer is not going to cut any ice whatsoever. Why? A lawyer is meant to argue in court and not to give opinion in a matter pending before a court of law. Surely he is not the one who is to do that. And consequently, even in corporate matters, which Justice Gill is pointing out, yes, corporate matters, there are matters which are technical in nature, where the opinion in regard to the interpretation and application of law is required. A lawyer is not meant to give opinion in a pending litigation matter. That's not the role of a lawyer. The lawyer is to argue the matter in court. And consequently, the opinion...
Yes, Justice Ahmed, quickly, we are running out of time, please.
Ms. Sandhu, if an opinion of a retired Chief Justice doesn't weigh with a litigant or with a judge, we, at least I, as being a judge, having served as a judge of the High Court, I would expect my officers to be doing the same thing for the same. And there is no way.
There is a very clear difference of opinion of Mr. Gupta, yourself with Justice.
Well, I trust my officers.
Well, we would like to move on. Amidst rising demands for greater transparency in the appointment of judges of high courts and the Supreme Court, the government is working on a proposal to put in place a new system where executive will have greater say in the appointments.
Under a Law Ministry proposal, a National Judicial Commission headed by the Chief Justice of India would be set up. It would also comprise an eminent jurist and the Law Minister for making appointments to the Apex Court. Under the proposal, the government plans a two-tier system with one servicing the Supreme Court and the other the 21 High Courts of the country. For the High Courts, a separate body will be set up for appointment of judges. The move to set aside the 1993 Supreme Court judgment, which led to the present collegium system, will require a constitutional amendment. Under the collegium system, the executive has no say in appointments as the recommendations of the collegium are final and binding on the government. Bureau Report, Day and Night News.
Justice Ahmednath, a quick comment from you. You prefer the earlier system where the executive had greater say, or the present system where the collegium takes the final call?
I think there is no difference between the two. The inquiry reports always come from the executive. The antecedents inquiries always.
But it is well known that in the earlier system before 93, the executive had a greater say, and now the collegium takes the final call.
Collegium takes the final call. The only place where so far as the capability of a particular candidate, judicial capability is concerned, it'll be it has always been the High Courts or the Supreme Court. But integrity wise or anything else, that
what do you think of the proposal of a two-tier system, a separate system for the Supreme Court judges and another system for the High Court judges?
It's always there. It's always been that way.
So you think there isn't much of a difference?
Yes, I mean, they're just covering up the same thing.
You know, more role of the executive. I don't understand what does that mean. Every day in the High Court.
No, where the names would come from the executive, from the governments, and not from the
that I do not subscribe to. Names emanating from the executive to the judiciary, certainly not. Why? I give a reason for that.
Yes.
The reason is High Court every day monitors the performance of different lawyers. Day in and day out, they are watching them performing in court. And therefore their opinion is based upon their skills in court as such. They are not on hearsays. Executive has no means to monitor the performance of a lawyer.
But Mr. Gupta, even in the present system, very often the Chief Justice and the members of the collegium are from outside the court. And I'm not sure if they know the functioning of the lawyers who are practicing the court.
The collegium, they are insiders. Chief Justice, who comes from outside, does not immediately make any recommendation. He acquaints himself, observes, watches the performance of the lawyers.
So you think the collegium system as it is now is okay and it should continue?
Quite right. I mean, executive stepping in is not going to make a difference as such, in the sense how, I mean, what kind of a role are we going to assign? So for us saying that the names to be initiated from the executive, I do not subscribe to that, because they do not know in reality.
The only thing which could be left to the executive functioning may be a sealed cover report regarding certain things. That's all.
No, but those reports, Justice Amarnath, are coming from the Intelligence Bureau.
Well,
and,
that's all.
They are not made public. I
They are
think
not made public.
Some people feel there's a lot of mischief in those
Maybe.
reports.
If there is, that has got to be rectified.
See, those reports need to be taken into consideration. Surely the collegium can again meet as such.
But should those reports not be made public so that you know, the person who is being accused of a certain thing can defend himself?
Certainly, certainly.
Then
That would
just
bring
get
in
Justice Gill into the discussion. Justice Gill, first your comment. Which system do you favor, the pre-93 system or the present collegium system? You've been a part of the collegium in the Punjab and Haryana High Court.
The executive must have an effective say in the selection of the candidates. If for quasi-judicial bodies, let's say like the Lok Ayukt, the High Court rulings and Supreme Court rulings are effective consultations, then why not for a High Court judge? You know, you're in the collegium, that's fine. The Chief Justice are all outsiders. The Chief Justice does not know as to the type of lawyers who are the capable ones. And my experience in the High Court is that the lawyers who are outstanding on the criminal side, they never get an opportunity to come before the Chief Justice, and they are the ones who lose out the most.
But Justice Gill, that is where
from the collegium.
Justice Gill, that's where the role of the collegium comes in. The members of the collegium can, of course, tell the Chief Justice. Does he not listen to the members of the collegium?